Hello, everybody. I'm attorney Nathan Howser, and in this video, I'm going to explain to you the workers' compensation deposition process, what to expect, and some guidelines for a successful deposition. What is a deposition? A deposition in workers' compensation is a very common question and answer session. It is not an interrogation. The attorney for the insurance carrier or the employer is going to be asking you questions about your work injuries, past employment, prior workers' compensation claims, and prior motor vehicle accidents. Since the year 2020, most depositions are taken on a virtual application like Zoom that you can access from your computer, iPad, or cell phone. If you use a cell phone or iPad, make sure it's charged and plugged in so you don't lose power and get disconnected from the deposition. So first and foremost, download the application necessary for your deposition and make sure that it's working beforehand. Make sure that you have a good internet connection and that you are the only person in the room during the deposition. You are not allowed to receive help answering questions. If you are my client, myself or another attorney on behalf of my office will be present with you during the deposition. What kind of questions will be asked? Most depositions will start with questions about your basic information and background, where you live, where you have lived prior, all of the jobs that you have had in your whole life prior to the job where you were injured, whether you had past injuries at those jobs, and whether you have had any motor vehicle accidents, and the details surrounding the past jobs and injuries. Then the attorney will ask you questions about the details of the current injuries, what body parts are injured, what doctors you've seen, what diagnostics you have completed, what treatment you've received, whether the treatment has been helpful, and what other treatment your doctor has recommended. Most depositions will end with the attorney asking you questions about your activities and daily living to see how your injuries have impacted your life outside of work and any limitations that you have doing certain activities, or if there are things that you are no longer able to do at all. These questions are very important, and I'll get into a very specific question to watch out for later in this video when I go over activities and daily living. General guidelines for success. The most important rule for the deposition is to tell the truth. Do not lie about anything in the case, even if you think it's going to help your case, or if you think that nobody will find out that you're lying. In a deposition, you will swear to tell only the truth, and you should answer truthfully to every question. Lying in a deposition will never help your case. A defense attorney will be asking you questions. Do not make the mistake of thinking that the defense attorney is your friend or trying to help you. Many defense attorneys will be very friendly to you because they want you to be comfortable and talk and talk and talk, which I promise will cause problems for your case. Keep your answers short and simple. If your response to a question is more than a few seconds, or if it seems like you are doing most of the talking, there is definitely a problem and it will need to stop. There are only certain exceptions to this rule, and I'll explain those later. A deposition is not the time to prove your case. If we need to prove your case, that will be at a trial. And don't worry, we will make sure that all of the necessary information comes out during the deposition. You should only answer the exact question that is being asked and then stop talking. Do not volunteer additional information. For example, if you are asked, did you report your injury to your supervisor? And you did. Your answer should be yes, and then stop talking. You should not say, yes, I reported the injury to my supervisor named Paul, but he didn't pay any attention to me. That response gives more information than the question asked for, and the answer of yes completely answers the question. If the attorney wants you to get additional information or details, wait until you are asked for the specific information before providing it. It may seem like this would make the deposition take much longer, but it actually makes it go much faster and much more smoothly. If you can answer the question with a yes or no, do it. I have 5 favorite answers during a deposition. Yes, no, I don't know, I don't remember, and not that I can recall. If any of those answers are the truthful answers to the question, use those. Not that I recall is an appropriate answer when you don't remember if you've had past injuries, past pain, or past treatment for a body part, but there's a possibility that you may have. For example, if you were asked something like, before your injury at this job, have you ever injured this body part before? Or before your injury at this job, have you ever had pain in this body part before? Or before your injury at this job, have you ever received treatment to this body part before? Look, life is long, and sometimes it's difficult to remember what you ate for breakfast yesterday. If you are not sure whether you had past injuries, pain, or treatment to a certain body part before your work injury, but you think there's a possibility, don't answer no to that question. A better response would be, not that I can recall. The reason is this. After the insurance does their search for past records, past injuries, if they do find that you had past injuries, pain, or treatment, it's much less damaging to your case than if you were to answer with a concrete no. Now, attorneys have 3 basic reasons to take a deposition. The first is to determine your credibility. If the attorney thinks that you're dishonest or inconsistent, they will likely fight more on the case, and they'll likely want to take your case to trial or settle your case for less money. But if the attorney thinks you're a good, honest witness, they tend to fight less on the case, and they'll likely not want to take your case to trial because they'll think that a judge will find it in your favor. So there's a better chance of reaching a higher settlement. The second reason is to learn the facts of your case directly from you. Oftentimes, the attorney will only have one side of the story from the employer, and there's always two sides to a story. So they want to know your version of what happened. And lastly, the attorney wants you to commit to a story. So later on, if you change your answers to those questions, those changes will be used against you. So it's important that you give truthful, accurate answers during the deposition. After the deposition, you'll have an opportunity to review the transcript and make any changes to your answers. But the goal is to make no changes or as few changes as possible. Take your time when answering questions and make sure that you listen to the entire question before you respond, even if you anticipate what the question is going to be. This is important for three reasons. You need to hear the entire question to know what's being asked, and a question can change at the end. If you answer too quickly, you might not be giving an answer to the question that's being asked. Also, if you answer too quickly or interrupt the attorney asking the question, you could prevent me from making an objection to the question. For some questions, I may even object and instruct you not to answer the question. However, if you answer too quickly, you prevent me from making the objection and possibly prevent me from instructing you not to answer the question. And last, the court reporter can only write down one person talking at a time. The transcript of the deposition should read like this: question, answer, question, answer. If you're interrupting the attorney or answering too quickly, the transcript will not be clear and it might be confusing for a judge or a doctor reading the transcript at a later time. If you don't understand a question, don't answer it. Say, I don't understand, and the attorney will need to ask it again in a way that you do understand. If you answer a question that you don't understand, it will be assumed that you understood the question, which can cause confusion. I have had to go to trial on cases just because my clients answered a question when they didn't understand it, and I needed to clear it up in front of a judge. So if you don't understand the question, say, I don't understand the question. I want you to assume that the attorney already knows the answers to the questions that are being asked, and they just want to see if you're going to tell the truth. This happens often where the attorney has verified certain information through reports or in some cases with an investigator, and they ask you the question just to see if you'll be honest. For example, many years ago, an attorney asked one of my clients, "What did you do yesterday?" My client responded, "I sold a motorcycle at my house." The attorney then asked, "Did you help the person who bought the motorcycle lift it into his truck?" My client said no. But the day before the deposition, the insurance company paid an investigator to sit outside of my client's house and film what he was doing that day. And the truth was that he did help lift the motorcycle into the buyer's truck. He was giving an answer that he thought was helpful for his case instead of telling the truth, and that alone significantly damaged his case. So I repeat the point, be honest with every answer that you give, even if you think it's going to damage your case, because lying will always damage the case more. During the deposition, the attorney will ask you to provide estimates with regards to dates, times, heights, or weights of certain items. If you're able to give an estimate, that's fine, but I don't want you to guess to any questions. When you guess the answer to a question, you'll forget what those answers were, and then your testimony can be inconsistent and you may appear dishonest. So if you have personal knowledge about something and you can give an estimate, please do. But if you're giving an estimate, make sure that you say that. For example, approximately 2 months or approximately 50 pounds. You may hear me make objections during the deposition, but even if I object to the question, you can still answer the question unless I specifically instruct you not to answer the question. When that happens, it would sound something like this. Objection, that question calls for attorney-client privilege communications, and I'm instructing my client not to answer the question. Some attorneys will then say, your attorney has instructed you not to answer the question. Are you going to follow his advice? You should say yes and don't answer the question. You will not get in trouble for not answering a question if it was at my instruction. That would be an issue between me and a judge. Answer all questions verbally. Don't use utterances like or shake your head or nod your head to answer a question. You need to give a verbal response, yes or no, because the court reporter cannot take down those gestures or sounds. Also, if you're talking about a body part, don't point to the body part and say here and here. You need to say with words what body parts you're referring to, like my neck, my right shoulder. During the deposition, you may hear me say something like, that's not the question that was asked, or remind you, please wait until the question is completely asked before you respond. Or I might tell you, you've answered the question. That means stop talking. If I say any of those comments to you during the deposition, I don't want you to feel like I'm being rude to you. I make those comments because I want to protect your interests and because I want you to follow the rules that I've given for answering questions. It's always to protect you. You'll be asked if at the time of your injury you had a second job with another employer, or if you're getting paid to take care of a family member through IHSS, in-home support services. If you had simultaneous employment, or if you are getting paid to take care of someone, you must tell the truth. Trying to hide that information can cause huge problems. One exception to the short and simple answer rule is when you're asked, where are you having pain or physical complaints? I want you to take your time with this question. A lot of people feel pressure during a deposition to answer fast, but I want you to take your time and make a list. Think about it from the top of your head down to your toes and explain each body part where you have pain. Also, if since the injury you have developed pain in other parts of your body, I want to make sure that you say those other body parts as well. If you've listed all the body parts and you feel like you may have forgotten to say one, you can say, that's all that I can remember right now. And when you remember, if it's during the deposition, you can say, I want to make a clarification. And you can say, I also have pain in this part of my body. Another exception to the short and simple answer rule is when you're asked, what are your job duties? When you're asked this question, I want you to explain in detail what your job duties are and what you physically have to do at the job. Explain all the things that you have to do repetitively or that are physically demanding, like heavy lifting, pushing, and pulling. I want you to explain in detail, but try not to ramble. Explain your job duties, but do it as briefly as possible. If you're asked how your injury happened, if it happened on a specific day, just say how the injury happened. Don't say something like, well, I got to work at 6 o'clock, I had my lunch, I went back to work, and then I was pulling a box from the shelf and another box fell on my head and my right shoulder. With that example, the answer should just be, I was pulling a box from a shelf and another box fell on my head and right shoulder. You don't need to tell a story about the day, just say how the injury happened. If your injury occurred over time, called a cumulative trauma or a repetitive injury, the attorney may ask you, when did your injury happen? And you should explain, it wasn't on a specific date, it occurred over time. If they ask you, when did the pain begin, and you are not sure because it didn't happen on a specific day, it's okay to say approximations, like approximately 2 years ago. You'll usually know when a deposition is almost over when the attorney starts asking questions about activities of daily living. These are important questions because a doctor or a judge may consider the impact that the injury had on your activities of daily living when they assign permanent disability or order permanent disability benefits to be paid. But there's one question I want you to be on the lookout for, and if you hear it, I want an alarm to go off in your head. And that question is this: are there any things that you are unable to do now that you used to be able to do before your injury? This is where some clients get into trouble. Don't say, I can't do this activity if you can do it, but it's painful or difficult for you to do so. There is a very big difference between something you cannot do at all and something that you can do, but it's painful or difficult to do. So if there are activities that are now difficult or painful when you do them, like putting on your shoes or standing for long periods of time, you should explain that and say, I have difficulty or pain when I do this specific activity, but don't say I can't do it. It is very easy to make someone look dishonest to a judge or a doctor if they say that they're unable to do an activity and then an investigator goes and films you doing the activity that you said you cannot do. During the deposition, we can take a break at any time, including if you just want to talk to me about something. Simply say, I'd like to take a break, and then we'll take a break. You are in control of the deposition. So if you need to take a break, just speak up and we'll take a break. Also, if you experience pain after sitting for a long time, feel free to stand up or stand behind your chair and hold the back of your chair while answering questions. You don't need to ask for permission. I want you to feel as comfortable as possible so you're able to focus on what's being asked and give correct answers. If you have had prior workers' compensation cases, you're going to be asked the details of those cases. You'll be asked the dates of injury, who your employer was, what body parts were injured, who your attorney was, how much was the settlement for, did you settle it leaving the case open or closing future medical care? Just do your best to recall the details of your past injuries. Nobody's memory is perfect. And one last thing that I want you to know, my number one priority during your deposition is to protect you and protect your rights. I will absolutely not let somebody harass my client or try to intimidate them during a deposition. If the attorney taking the deposition is being inappropriate with their conduct, I'll stop the deposition. Unfortunately, an attorney is allowed to be annoying and some are. They're also allowed to ask questions that may be uncomfortable for you to answer. But if the attorney is trying to harass you or intimidate you, I'll end the deposition. So let's review the general rules and guidelines for the deposition. Be honest with every answer that you provide in the deposition, even if you think the answer will damage your case. Always tell the truth. Keep your answers short and simple. Only answer the exact question being asked and stop talking. Do not volunteer additional information. If you have any questions about workers' compensation rights or have specific questions about your case, call or text the number on the screen and we'll be happy to give you an evaluation completely free. If you found this video helpful, please give it a like and make sure you subscribe to my channel for more videos about California workers' compensation. Once again, I'm attorney Nathan Howser. Thanks for watching and talk to you soon.